Greetings, everyone. My name is Jonathan Bailey, and I'm from the site Plagiarism Today, which can be found at plagiarismtoday.com. First off, I want to apologize a little bit if I sound a little scratchy, if I turn to cough. I am suffering from a pretty nasty head cold, and though I'm held together by cold medicine right now, I can't guarantee that's going to be the case in 3 to 5 minutes. But today I really quickly wanted to say thanks to all my readers and friends who have sent me the Copyright Math TED Talk over the past couple of weeks or so. I have indeed watched it. I did indeed enjoy it. It's actually very humorous. It's done by Rob Reed. He's formerly from Diamond Media. They were the ones who made the Rio MP3 player and were sued by the RIAA for that. And he's more recently the force behind Rhapsody Music Player. So very involved in the music industry, but obviously has some very unique views on copyright law. And the basic gist of the copyright math, well, one of the key gists, I should say, he actually makes several points, but one of the key points he talks about is how expensive, outrageously expensive copyright infringement is, and how your iPod can be worth almost as much as all the money there is in the world in terms of infringement. Um, and I see this argued banted around a lot. In fact, there was another one called the $8 billion iPod at one point, talking about all the music stored in your iPod and how much it would actually be worth if the maximum statutory damages were applied under copyright law. And I admit the damages range in copyright law is something that's worth discussion. It can be something that's oftentimes worth a great deal of concern. But I get a little frustrated with some of this math, this quote-unquote copyright math, because it's taking something that is technically true but not realistically true or feasibly true and trying to use it for shock value. Basically speaking, the false premise in this is that copyright law has somehow determined an infringement is worth $150,000, and that's simply not true. Copyright law in the United States has established a range of damages, statutory damages, from $750,000 to $150,000, and there's a lot of variables that come into play with that, including how serious the infringement is the person an innocent infringer under the law, etc. But a judge and a jury can go anywhere from $750,000 to $150,000. Now that's a huge range. I don't have to spell that out, especially when you're looking at a lot of infringements. If you're looking at thousands and thousands of infringements, that can be a wide swath to cover. But basically speaking, it's very, very rare to see damages go onto the higher end of that scale. Even the more outrageous Jamie Thomas rulings still trended toward the lower side. I don't think I've actually seen a ruling where the statutory damages were higher than $100,000 per infringement ever, so still nowhere near the 150. In fact, the only time I've seen 150 reach, now that I think about it, was a case where the other side didn't show up. And so basically, if you show up in court, expect not to have to face $150,000 damages. No one really does. So that's problem one. With the problem two is that that's not what the infringement is worth. Statutory damages are not designed to sort of this is the copyright holder getting their money back type situation. That's not how statutory damages work. Statutory damages are under the law designed not necessarily to be punitive, but to make it so that A, suing for infringement is worthwhile, and B, it is not better for the defendant in the case to simply infringe and go, my bad, and then pay the actual damages. Under the law, actual damages are the term for what an infringement is worth monetarily. That's when you pay exactly what damage you did. Statutory damages by nature go above and beyond that to make that person pay more. Like I said, it's not the same thing as punitive damages, though admittedly there's a whole legal debate about that meaning and whether statutory damages are punitive in nature. That's a whole separate discussion. But basically, statutory damages are designed under the law to be worth more than the actual damages. Now, one of the reasons we're seeing such outrageous copyright verdicts, and we're continuing to over such small and petty matters, is because it is so expensive, so difficult to sue for copyright infringement. It takes tens of thousands of dollars to litigate a copyright case because it's got to go to the federal court system. It takes many, many years in some cases to litigate even a simple case. And so the damages have to be high in order to make it worthwhile. And even if the damages aren't high, there's still going to be this ultra-high attorney fees and whatnot and other issues. So honestly, one of the things we need if we want to get these damages in this situation under control is we need some kind of copyright small claims court where more minor issues can be litigated cheaply and effectively. This would help both plaintiffs and defendants. It would help, bring more people into the copyright fold, so to speak, and be able both to defend themselves and be able to file suit as needed. But that's something that the U.S. Copyright Office is taking a look at, and is a long, long way off, probably 10 years or more, truth be told. So, copyright math, a lot of fun, but be a little wary of some of the claims. I'm just saying, it's a great video. Rob Reed, I know, understands this. He's someone that's been on the wrong side of a lot of lawsuits, so he knows this. He's just doing this for humor and shock value. In the meantime, though, give it some thought, do your own research, and until next time, this is Jonathan Bailey, signing off.